is the defense ready to proceed?
Yes, Your Honor.
Okay, at this time, Mr. Johnson, I would like to proceed with formal arraignment.
Yes, Your Honor.
And if your client could please come to the podium. Mr. DeHart, if you could please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth? All right, Mr. DeHart, you are before this court having been indicted by the Blount County Grand Jury in 29339 with first-degree murder, attempted first-degree murder, felon in possession of a firearm ×2, felon in possession of a handgun, deploying a firearm during the commission of a dangerous felony ×3, possession of a firearm during the commission of a dangerous felony ×3, aggravated assault against a first responder ×2, reckless endangerment, tampering with evidence, evading arrest with risk of death or serious bodily injury, aggravated assault, resisting arrest, and failure to maintain lane. You received a copy of the indictment, Mr. Johnson.
Yes, Your Honor. We've received a copy of the indictment. We have reviewed it with Mr. DeHart. We waive formal reading.
I have previously gone over his charges with him. Since the last time you were in court, Mr. DeHart, the state of Tennessee has filed a notice that they intend to seek the death penalty in this case. Do you understand that?
Yes, sir.
And Mr. Johnson, have you gone over that with your client?
Gone over that notice, Your Honor, with Mr. DeHart, as well as a notice to seek life without the possibility of parole.
And you've gone over the minimum and maximum and what all that means as far as the defense in this case.
We have, Your Honor.
Right. And since that time, we have also appointed you co-counsel, correct?
That's correct, Your Honor.
Upon the filing of the death penalty notice, Mr. DeHart, at that time you were entitled to death penalty qualified counsel, and the court has appointed Mr. Robert Kurtz and Mr. Johnson in your case. Do you understand that? All right. We have previously gone over everyone's calendar, correct, General?
We have, Your Honor.
And I believe that after review of everyone's calendar, we have an agreement as to a scheduling order in this case. Is that correct?
Yes, sir.
Yes, Your Honor.
Okay. And at this time, before we get to that scheduling order, does Mr. DeHart have a formal plea, Mr. Johnson?
There's a plea of not guilty, Your Honor, to all charges.
Correct, Mr. DeHart? All right, I'll accept that plea at this time. We need to set the case for trial. Based upon the scheduling order that we went over and on the calendar, it is my understanding that we will set a trial in this matter for April 13th, 2026. Is that correct?
Yes, sir.
At that time, we will then set jury orientation for February the 23rd of 2026. Is that correct?
Yes, sir.
Yes, Your Honor.
Individual jury voir dire will be March 30th through April the 3rd of 2026, correct?
Yes, Your Honor.
And then we will have general voir dire to begin on April the 13th, correct?
Yes, Your Honor.
Any motion requesting submission of a jury questionnaire must be filed by May the 5th of 2025, and the response is May 19th, 2025, and those motions will be heard June 5th. Is that correct?
Yes, Your Honor.
Let's see. The week of April the 6th through the 10th of 2026 will be available on both of your calendars as well as the court's calendar for any possible motions in this case, correct?
Yes, Your Honor. Yes.
Let's see. Read notice would be filed by defense by November the 14th, 2025.
Yes, Your Honor.
As far as pretrial motions and motions hearing, prior to each motion date, the state shall make a written request of all agencies or individuals involved in the investigation to provide any materials not provided to the district attorney's office.
We will have, we have, and we will again, Your Honor, yes.
Okay, the parties shall number their motions, and any responses shall reference the motion number to which it is a response. You want an agreement?
Yes, Your Honor.
Yes, Your Honor.
And the following dates will be scheduled for all pretrial motions. Motion hearing is scheduled March the 31st, 2025. Any motions previously filed and pending shall be addressed on that date unless specifically reserved by agreement of the parties, and the court should be notified of that. All additional motions to be heard should be filed by March the 3rd of 2025, with responses by March 17th, 2025. Does that sound correct?
Yes, Your Honor.
Yes.
A motion hearing is also scheduled on June the 5th of 2025. All motions to be heard shall be filed by May the 5th, 2025, and responses by May 19th, 2025. A motion hearing is also scheduled for September the 30th of 2025. All motions should be filed by September the 2nd, and responses by September the 16th of 2025. A motion hearing is also scheduled on January the 14th of 2026 at 10 a.m. All motions should be filed by December the 12th, 25, and responses by January the 5th, 2026. There is also a motion hearing scheduled March the 3rd, 2026. All motions should be heard, or be filed by February 3rd, and responses by February 17th, 2026. All discovery deadlines will be placed on this court's docket for discussions and be prepared to have that hearing on March the 31st of 2025.
Yes, sir.
Yes, Your Honor.
Gentlemen, does that truly and accurately state the scheduling order in this case?
It does, Your Honor.
It does, Your Honor.
It is my,
Only question, Judge, when numbering the motions, I know several motions have already been filed. Do we want to go back and assign numbers to those motions, or do we want to start with number one on the next motion? It doesn't matter to me, but I know we have a number of motions that have already been filed. Does
Mr.
Ms.
Johnson, do you want to respond?
Yes, my suggestion, Judge, is let me go back and take a look, because there were a few filings before our firm got involved in this case. Let me go back and take a look, and my suggestion is we go back and we number those. That way, for record purposes, it's clear that we have a numerical system that goes to the entirety of the record.
And if there's previous motions that the defense does not wish to adopt or proceed on, I'll need an order that states so that we can remove those from the record.
Yes, sir.
And then we'll go back and number the ones that are still going to be litigated.
Yes, sir.
Okay, it's my anticipation, gentlemen, that this is going to be long and extremely complex litigation. I have set a court date that is into 2026, which is far beyond what this court normally sets for a trial date. I've done that because it is complex. The litigation is going to require several hearings, several motions. It is going to be moving forward to that date. I do not intend to move that trial date. We are going to work towards that trial date. It is a firm trial date as well as the motion dates. So we have plenty of time and docket allocation for that trial date to happen.
Say we'll be ready, Your Honor.
We'll be ready as well.
Anything further?